Coming to you from a cozy little condo high atop Old Fourth Ward, Atlanta. Welcome to The Ron Show on America One Radio. Here's your host, Ron Roberts.
It was after the bombing of Pearl Harbor. President Franklin Delano Roosevelt addressed Congress to stir the country into action. Now, reportedly in Japan, the admiral who planned the Pearl Harbor attack, Admiral Isoroku Yamamoto, allegedly wrote in his diary. Cannot confirm this. But allegedly, he wrote in the diary, "I fear all we have done is to awaken a sleeping giant and fill him with terrible resolve." It is July 2nd, 2024. In 2 days, we are to celebrate our independence, 248 years as a nation free of tyranny in these United States. And yet it was on July 1st, 2024, that a John Roberts-led Supreme Court walked us closer back towards the potential for tyranny in these United States. Forgive me if I have a hard time mustering up the energy and enthusiasm to celebrate our Independence Day on Thursday. In our nearly 248 years of existence in this country, never has a citizen feared the potential that someone holding an office, the one office in this country, could be free of culpability, of repercussion for illegal acts in the eye of the law. And now going forward, we all live as Americans in a perpetual state of unease, depending on who's in that office, what party they belong to, I suppose, that there could be blowback, and that the person providing that blowback to his or her political enemies can be free of repercussion. Supreme Court Justice Sonia Sotomayor, in her dissent in yesterday's historic 6-3 decision, granting the former President of the United States and current and future presidents, by the way, broad immunities for, quote, official acts, wrote, "Never in the history of our republic has a president had reason to believe that he would be immune from criminal prosecution if he used the trappings of his office to violate the criminal law. Moving forward, however, all former presidents will be cloaked in such immunity. If the occupant of that office misuses official power for personal gain, the criminal law that the rest of us must abide will not provide a backstop. With fear for our democracy," she writes, "I dissent." No respectfully, just I dissent. Obviously, January 6th comes to mind. The slates of fake electors come to mind. The infamous call to Secretary of State Brad Raffensperger here in the state of Georgia. Never mind the communication between he and those on his executive branch staff. All of that now, the conversations with his executive branch, all of this is now protected. He is now immune from having any of that correspondence used to confirm the acts he tried to partake in to overturn the 2020 election. But let's just go through the times while in office he advocated for violence. And now this Supreme Court has given him or anyone who has the office from here going forward the leeway of saying, that was an official act. And that has to be debated about in court. And watch, so much of what falls as gray area is, was that an official act? Was that an unofficial act? Now that has to fall back to an appellate court before it arrives back at the U.S. Supreme Court. This U.S. Supreme Court that we have how much faith in adjudicating fairly and without bias? Samuel Alito did not recuse himself. Clarence Thomas did not recuse himself. Both of those men having spouses heavily biased in their actions. Those two clearly themselves being biased, bought off. None of the three justices that the president, who was involved in the case before them, recusing themselves for obviously biased reasons. Just in this man's presidency, whether these are official or unofficial acts, and it can be argued that they could be, all the way up to that Supreme Court, this president called for violence. July 2017, speaking to law enforcement officers in Long Island, New York, he encouraged police officers to be rough with people that they were arresting. Please don't be too nice. In August of 2017, in the aftermath of the rally in Charlottesville, Virginia, remember that? Then President Trump failed to condemn the violence and said many sides were to blame, failing to distinguish between those who participated in the Unite the Right rally and those who showed up in opposition to it. October 2018, he's at a Montana campaign rally. He praised Montana's then Congressional Representative Greg Gianforte, the state's current governor, for previously assaulting a reporter. Any guy that can do a body slam, he's my type. This is just while he was president. I hadn't even gone back to the rallies in 2016 where he was encouraging his supporters to beat people up who showed up to protest him. While he was president, October 2019, New York Times reported various strategies Trump had allegedly deliberated to keep migrants away from the southern border, including a water-filled trench with snakes or alligators and shooting migrants in the legs to slow them down. Governor Greg Abbott, of course, said, well, why don't we just put some barbed wire in the water? May 2020. Then President Trump used violent rhetoric when referring to protests in Minneapolis in the wake of George Floyd's killing. Tweeting, when the looting starts, the shooting starts. By the way, this complete list is on Axios. I'll give you the link at ronshowatl.com. June of 2020, Trump threatened to use the U.S. military to quell Black Lives Matter's protests. If a city or state refuses to take the actions necessary to defend the life and property of their residents, then I will deploy the United States military and quickly solve the problem for them. An official act? If he turns the military on protesters? August 2020. Then President Trump expressed interest in sending the National Guard to Portland, Oregon to confront protesters. We could fix Portland in, I would say, 45 minutes. September 2020. Trump lauded law enforcement officers for killing Michael Forrest Reynolds, a self-described Antifa member suspected of killing a right-wing activist the previous month. That's the way it has to be. There has to be retribution, he said. Same month. Offered the chance to unequivocally condemn white supremacist violence during the first presidential debate. Trump failed to do so, instead telling the far-right Proud Boys that they should, quote, stand back and stand by. We remember that. Of course, January 6, 2021. At a rally preceding the Capitol riot, Trump repeated false claims that the election had been stolen and told supporters that, quote, we're going to walk down to the Capitol. You'll never take back our country with weakness. Official acts? Unofficial acts? Who knows? There are some that say Justice Sotomayor's dissent was hyperbolic. To that I would say, where have you been since 2017? Have you not been paying attention? There are Republicans who want to assure us they would never stand by and stand back if a rogue Donald Trump in office were to cross the line. To which I say, we gave you that chance for 4 years and you failed. And I could quibble about the impeachment processes, how patently obvious it was that there was some kind of coordination between the Russian government and the Trump campaign. Otherwise, why were they meeting so damn much? Why did so many people go to prison and serve time for it? The beautiful call to Volodymyr Zelensky, then and now president of Ukraine. They had opportunities. They whiffed. They gave this same man that they knew was a deeply flawed individual, but his ideas, they gave this same man 3 Supreme Court justices. One of whom, by the way, was supposed to be seated by his predecessor. Given some new rationalization that had never existed before, Mitch McConnell decided to invoke it. And then seated another Supreme Court justice, ignoring that same rationale as he's on his way out the door. So those 2 justices, 2 of the 6, seated by Donald John Trump, neither of whom recused themselves in Trump's immunity case, are forever attached to that governing body, to that judicial body. What happens from 2025 to 2029 with the makeup of that bench, no one knows. No one can predict. We can surmise, depending on the outcome of the presidential election, that some of the older statesmen on that bench may decide to step down. If Trump is reelected, you can rest assured that the well-paid Justice Clarence Thomas, age 75, will likely step down, safely knowing that someone who replaces him will match him ideologically, and probably in their late 30s or early 40s, as the GOP tends to want to try. Justice Alito, only 2 years younger. Maybe he too steps down. On the left, because we held on too long with Justice Ruth Bader Ginsburg, as was her right as a justice for her lifetime appointment. Suddenly we're concerned about the 69-year-old, much younger, Justice Sonia Sotomayor. Here's the thing, though. 3 of the 4 justices by age, by seniority in age, are conservative justices. And yesterday, the Supreme Court, if they didn't before with the Dobbs decision, placed themselves securely high in priority on the list of factors going into who they decide to vote for in November of 2024. Who will be the next president of the United States? The Dobbs decision, yesterday's immunity decision, the Supreme Court on the whole. The legality, the legitimacy of the Supreme Court now is a campaign factor. If it weren't before, it certainly is now. Yamamoto said after Pearl Harbor, "I fear we have awakened a sleeping giant." The Supreme Court adjudicates with impunity. They don't care. They're untouchable. Ironically, with an 81-year-old Democratic Party nominee, I have to also point out to them, however, Father Time is undefeated. We have a lot more to discuss. Let me catch my breath. The Ron Show continues on America One Radio. You can follow The Ron Show on your preferred social media platforms. That would be at Ron Show ATL, the Twitter X platform, Threads. I'm on that. Facebook, Instagram, you name it, that's where I am. You can see. Yesterday, I took to the Twitter X platform to just simply exasperate at the many and varied ways that conservatives in this country are willing to stretch, bend the rules to alter what this country is and has been known for so many years. My tweet yesterday, I can't help but marvel at how far conservatives are willing to go in destroying this country's revered institutions, all to coddle and protect one deeply flawed, despicable man. The adjudication yesterday that we got from the Supreme Court will have lasting effects. One for the ages, as Neil Gorsuch wrote. In today's Georgia Recorder, you can read this column at georgiarecorder.com. I'll include it in the show notes at ronshowatl.com. Marshall Tannick, a Minnesota employment law attorney with the law firm of Meyer, Neuse, and Tannick. Did I say that right? Meyer, Neuse, and Tannick?
Correct, Ron.
Good. All right. Wrote that he pointed out Neil Gorsuch's famous line, but he also spoke in some pretty draconian ways how a president, while in office, could take issue with something the Supreme Court did and send SEAL Team 6 in to take care of that. Talk to me, if you don't mind, Marshall, about how not hyperbolic that sort of premise is based on yesterday's decision.
Well, thank you, Ron. Appreciate the opportunity. I wrote my piece even before I fully had a chance to absorb the decision. I wanted to get it out quickly, so I hadn't read the complete decision fully at the time I wrote that, and much of what I said was somewhat parallel to what Justice Sonia Sotomayor said in her dissent, although I expanded on that. But at any rate, some people are saying in the immediate aftermath of yesterday's decision that, well, it's not too bad, chill out, it's not as bad as you think. And I dissent from that view. I think it's worse than some people think. I think the dilemmas that I portrayed in my piece and in Sotomayor's dissent are just previews of what could happen, especially in light of the fact that the Trump campaign and the former president himself have already said they're going to do those things. They have a 900-page missive that explains and examines what they plan on doing, and I think we can take them at their word for it, and now they have free rein to do it. The its include some of the more dramatic matters like the SEAL Team 6 issue, but other things too. Since the president cannot be essentially held responsible for undertaking any action that's within the president's official or constitutional duties, which are very broad, taking bribes to appoint ambassadors, taking bribes to appoint office holders, in fact, exacting a fee on people to be employed by the government, are among the things that could and possibly will happen. I refer to it as auctioning off government jobs. So everything from fairly mundane things like day-to-day operations of the government to major matters like killing political rivals, I think could occur, and the Supreme Court has opened the door and not only invited it, but perhaps even encouraged it.
I'm curious to see what the left will do, what pundits will say, politicians as well, when they speak on the right about the weaponization of the Justice Department. Is this not a weaponization of the executive branch?
Well, it is, and I think some of the Trump supporters have said that we plan on doing that as a tit for tat or quid pro quo. You did it to us, so we're going to do it to you. And I think some people who are suggesting, well, it's not going to be that bad, they'll back off once they get in office, I think the exact opposite. They can use the powers of government to essentially destroy other opposition forces. So I think the door is wide open now, and I think those people who are sounding the alarm bells, I think are understating the potential difficulties that the country is going to face. And I don't mean to say that as a hyperbolic exclamation. I think it just is a legitimate warning that we have a five-alarm fire going on here.
We are a nation of checks and balances, and unfortunately, we have seen since 2017 that those checks and balances are flawed when partisanship comes to the forefront, whether it's the Supreme Court, whether it's the legislative branch when it comes to too obvious, in my mind, impeachment inquiries. Maybe you're like, I'm losing faith in that system of checks and balances because I've seen what hyperpartisanship does to erode it.
Well, I think you're on the right track, unfortunately. I think the checks and balances were shaky and have been over the last 7 or 8 years, and I think this decision has the potential or the actuality to essentially not only diminish, but perhaps even eviscerate the major checks and balances, at least on the executive level.
So going forward, what recourse do the American people have other than voting and hoping that the next 4 years, is there anything other than waiting it out and for justices to either step down and die and to be replaced by liberal justices? I mean, this seems like a 10, 12, 14, 16-year project.
Yeah, or longer. Well, certainly the pat answer to that is vote and make sure that the people who would undertake to destroy democracy do not get elected to office. but that's even made more difficult by recent developments as well. But voting, of course, is one way. But if that doesn't work, other ways people are girding up for what may be a tsunami of weaponization and retaliation and vengeance-related action, lawsuits against people, both criminal and civil, a misuse of the powers of government, and people are girding up for that, preparing for it, I guess, in some ways. Certainly public opinion can play a role, and people like you, Ron, and others have to continue to point out these concerns and try to raise people's consciousness and awareness. It's not so much the people who listen to your program and follow the progressive line that are the issue here. Is the people who don't care or uninterested or disengaged, and those people just have to be brought into the fray and made to understand the huge stakes that are involved, rather than just a Alfred E. Newman, what me worry attitude. They have to be aware of the significant dangers and what it poses to them and their families and their futures.
Marshall Tannick with the law firm Meyer, Newson Tannick in today's GeorgiaRecorder.com. I'll include that in the show notes at RonShowATL.com. Thanks for joining the Ron Show today.
Thank you, Ron. Good points you made.
Broadcasting 5 days a week to make common sense common again. This is The Ron Show on America One Radio.
Even before yesterday's Supreme Court decision granting former President Donald Trump immunity in his, air quotes, official acts as president, yet to be determined through the appeals process, which may wind up before the same Supreme Court that made yesterday's immunity decisions. It's just comical. And how are we not the laughingstock of the world? We beat our chests so much talking about our representative republic, democracy, and our rule of law, and then we have this. It's embarrassing. It really is embarrassing. Having friends, my dearest friend Ludwig, who is a new American citizen as of last summer, gets to celebrate his first 4th of July as an American citizen. My friend Jonathan, who is a Mexican-born new American citizen, celebrating his first Independence Day as an American citizen, and you just shake your head. This is my home country where I was born and raised, and grew up to believe in following the rule of law and obeying the law and participating in our electoral process. And the last 7 years have been really tough. They really have. They've just been really tough. 9/11 was very tough. The aftermath, the two ridiculous wars that were completely unnecessary to accomplish what we needed to accomplish in retribution for 9/11 were really tough. Housing crash, very tough. The last 25 years have been really tough as an American citizen, but the last 7 plus, oh my God. And it's not all on one man, because I can cite Mitch McConnell. I can cite Donald Trump, obviously. But Chief Justice John Roberts plays a large role in the direction this country has taken and in the toxicity that exists in our body politic. I was listening to the New Abnormal. It's a Daily Beast podcast. And on it was a guest by the name of Lisa Graves, host of the Grave Injustice podcast. Let me give her full credit for that. Anyway, the conversation then centered around the Supreme Court being untouchable with all of the ethics issues swirling around Samuel Alito, Clarence Thomas, and John Roberts refusing to come testify before a Senate subcommittee on those issues.
I think John Roberts is going to go down in history as one of the worst chief justices of the United States, one of the worst justices in the United States. He's done everything he can to try to manipulate the process, to avoid and block efforts by the Senate to hold the court accountable, to insist that it abide by just common sense ethical rules that every other court in the country has to follow. And like you said, he thumbed his nose at the Senate Judiciary Committee and refused to come to that hearing. And the Senate Judiciary Committee, Senator Durbin, let him get away with that. The fact is that it didn't have to be that way. He could issue subpoenas. Right now, the Senate Judiciary Committee could demand that Alito come and testify before the Senate. And if he refuses, issue subpoenas insisting that he and his wife testify about the flying of these flags and about his failure to recuse himself from these January 6th cases. But not just him. Also, Clarence Thomas, who has failed to recuse himself from cases involving, directly implicating his wife's role in trying to stoke the insurrection and the effort to, have a coup in our country and nullify the results of the 2020 election. They should be called to testify along with the billionaires who've been bankrolling their luxury lifestyles. And John Roberts himself should have to testify. Or Congress should take action to have consequences for them. They can change their budget. They can impose term limits on these judges. They can begin in the House impeachment proceedings. Of course, they can't proceed with the House being dominated by Republicans, but they can file those measures, try to get that ball rolling. There are a lot of things that these members can do. And as you point out, one of the most important things they can do is be talking to the American people about what's at stake. One of the worst set of election spending I've ever seen in my life were the ads that were running in 2016 in Wisconsin against Ron Johnson, telling him, Ron Johnson, do your job. Get Merrick Garland a hearing. That message did not convey to the people of Wisconsin what was at stake if the next president was Trump and if he appointed the type of extremists that were on his list. I don't know how many tens of thousands or possibly millions of dollars went into ads against those Republicans, with that message that had no content, did nothing to tell the American people that we really were on the brink of losing Roe versus Wade, that we really were on the brink of losing additional key protections for voting rights and for fair maps. Since then, though, in the 2022 election, in the 2023 election, there has been a vigorous pushback by state-based groups to really make it clear that this court is coming for our rights and we need to band together against them. So there has been some messaging, but unfortunately, we have not seen the leadership in the Senate insist that we have the kinds of hearings, the kind of accountability, the kind of pushback, the kind of calling back that's necessary in the face of this kind of corruption, the face of this bias, and actually, as you point out, the real broader extremist agenda that this court is unfurling as if it were a court and not just a handful of politicians handpicked by Leonard Leo and his billionaire backers in order to destroy our rights and destroy our freedoms. So we have a lot of work to do to get that message out, to get people to demand action by the Senate and to support people like Senator Blumenthal, who's done that terrific investigation of the RV and more. But that's not enough. We have to have more leadership from the Senate and from the House in order to take back our courts.
Let's stick to the John Roberts theme here, by the way. It was 11 years ago today that the same Supreme Court gutted the heart of the Voting Rights Act and the Shelby County v. Holder decision. Things have changed dramatically, John Roberts wrote back then, and things have changed even more dramatically since then, because since then, nearly 100 restrictive voting laws have been passed in at least 29 states, according to the Brennan Center for Justice. Writing for the Brennan Center, Jasleen Singh and Sarah Carter filed this story about a year and 1 week ago, as a matter of fact. In this piece, commemorating the then 10-year anniversary of Shelby County v. Holder, they wrote, along with a prior decision narrowly interpreting constitutional protection for voting rights, Shelby County also sent a message to the nation that the federal courts would no longer play their historic role as a robust protector of voting rights. In the years since, the court has repeatedly confirmed this, signaling to states that they could pass restrictive voting laws without fear of legal consequence. The Supreme Court's recent decision in Allen v. Milligan upholds the Voting Rights Act's protections against racial gerrymandering, not against, however, voting restrictions. As a result, the country has witnessed a barrage of restrictive voting legislation over the course of the last decade, reaching a fever pitch after the 2020 election and showing no signs of abating. While the trend of restrictive voting legislation began before Shelby County, its effects were largely mitigated by the preclearance process and court decisions that blocked or blunted new measures to curtail voting access. The Brennan Center has been tracking and cataloging this trend of restrictive voting legislation from its inception. Legislation is categorized as restrictive if it contains one or more provisions that would make it harder for eligible Americans to register, stay on the voter rolls, or vote as compared to existing state law. Since Shelby County was decided, at least 29 states have passed 94 restrictive voting laws. While a few of these have been blocked by courts repealed, most are still in effect, and at least one continues to operate in each of the 29 states. I'll give you this link, you know this, in the show notes at ronshowatl.com. Georgia and the entire Confederacy outside of Virginia, among the 29 states that have enacted restrictive voting laws since Shelby County v. Holder. Georgia among most of the solid South, excluding Kentucky, Virginia, Tennessee, and Arkansas, among the states previously subject to preclearance that enacted restrictive voting laws after Shelby County v. Holder, part of the Voting Rights Act. This piece continues. Not all restrictive laws are created equal. Some, like those passed in Iowa, Florida, Georgia, and Texas in 2021, are omnibus bills that include many restrictive provisions. Still, it is notable that at least 7 states have passed 5 or more restrictive laws since the Shelby County decision. Arizona, a state that was previously subject to preclearance, clocks in with the highest number of restrictive voting laws, 8, passed in any one state since Shelby County 11 years ago. On the other hand, some states have enacted 1 or 2 restrictive provisions, but on balance have expanded voting access more than they've restricted it in the past 10 years. Among such states are New Jersey, New Mexico, New York, and Utah. Many of these new laws are racially discriminatory. There is ample evidence that these kinds of laws fall hardest on communities of color, and a number have been struck down by courts as racially discriminatory. The gaps between turnout rates for white voters and voters of color have grown in the years since Shelby County, including in jurisdictions previously covered by preclearance. You think that's a mistake? You think that's on accident? You don't think that was up by design, my friends? Research also suggests that many of these laws may have been passed with racially discriminatory purpose, as some courts have also found. Far from racial discrimination in voting being a specter of the past, as Shelby County opinion presumed, there is ample evidence that it continues to play an active role in the continued suppression of voters of color. The restrictive laws passed in the last 10 years target every aspect of voting, including making voter registration more difficult, curtailing early voting opportunities, closing polling places, and limiting voter assistance. However, a substantial portion of the restrictive laws passed since Shelby County coalesce around 2 major trends: strict voter ID legislation just after the decision and limitations on mail voting after the 2020 election. Something I'll touch on in just a few minutes. Going to take a quick break. We're also going to come back and discuss the ramifications on the Trump immunity decision yesterday, what impact it'll have on the case here in Georgia, the election interference case. This is The Ron Show on the American One Radio app at AmericanOneRadio.com. All right, final 12 minutes or so of The Ron Show. Can I tell you that like, with the 4th being on Thursday, I was kind of eyeing this to be a holiday week, maybe airing some best ofs. No. Supreme Court got a Supreme Court. And the debate happened last week, so the time marches on, the show marches on. I'm pretty sure I'll be off Thursday, maybe Friday. Nonetheless, and hopefully it'll just be one of those quiet remainder of news weeks, but we've got so much to cover. The Trump immunity case yesterday, the Supreme Court's decision, leaving a lot of folks wondering what's going to happen at the state level, because they are a federal judicial body, and not everything that happens at the federal level has ramifications at the state level. For example, Donald Trump's New York hush money case. He is set to be sentenced in 9 days. The former president of the United States set to be sentenced in 9 days. However, Trump is going to try to get that set aside after yesterday's ruling. The Associated Press reporting, Michael Sisak, Jake Offenhartz, reporting that former President Donald Trump's lawyers have asked the New York judge who presided over his hush money trial, the same judge that Donald Trump was just smearing and raking through the mud, they're going to go back to that same judge to set aside his conviction and delay his sentencing, scheduled for next week. The letter to Judge Juan Merchan cited the U.S. Supreme Court's ruling earlier Monday on presidential immunity and asked the judge to delay Trump's sentencing while he weighs the high court's decision and how it could influence the New York case, according to the letter obtained by the Associated Press. The lawyers argued that the Supreme Court's decision confirmed a position the defense raised earlier in the case that prosecutors should have been precluded from introducing some evidence they said constituted official presidential acts according to the letter, to which I would argue the hush money was paid prior to his being president. All of the acts that occurred before his being president. So is there evidence? This is one of those deals where, like, at the time it was legal and the case has already been adjudicated on, so there's no going back. You can't go back and unintroduce evidence after the fact. Anyway, in prior court filings, Trump contended he is immune from prosecution for conduct alleged to involve official acts during his tenure in office. His lawyers did not raise that as a defense in the hush money case, but they argued that some evidence, including Trump's social media posts about former lawyer Michael Cohen, so now social media is an official act as president, come from his time as president and should have been excluded from the trial because of immunity protections. The Manhattan District Attorney's Office declined to comment Monday night. But watch, they're going to try and affect his convictions based on this immunity plea. Another question asked, what does yesterday's decision do with Fani Willis? Professor Anthony Michael Christ, Georgia State University, who's welcome to be on this show. I've invited him many times. Just 5 minutes, 10 minutes, dude. Anyway, seems like a nice guy. We interact on Twitter every once in a while. Was on with Rose Scott yesterday on WABE, and he sort of wandered into what sort of effect this could have on the Fulton County District Attorney's case. Rose's question was...
Let me ask you this, because someone may be wondering, well, Professor, when you are president of the United States, even if you are just days away from not being president of the United States, but when you are in full capacity as president of the United States, aren't you always in an official act, technically?
Well, that's what Donald Trump argued. Donald Trump argued that anything a person does while they are the sitting president of the United States is by default an official act. Now, the Supreme Court didn't buy that broad kind of immunity, but what they did say is that when the president speaks to the public, for example, there's a presumption that there's some kind of formal act that's involved there because presidents have to speak to the public. On the other hand, if a president is doing something that is purely in their private interest, for example, they're doing something for a purely partisan reason, right? They're doing it for their reelection as a candidate for office. That does not get the kind of presumption of immunity that would attach to other kinds of actions. And so the district court here in D.C. and, of course, the Fulton County Superior Court later on as well will have to parse out these different kinds of conduct that are involved in the indictments and determine whether they're official acts, unofficial acts, and if that presumption of immunity can be overcome if they are, in fact, non-core official acts.
Well, if the president of the United States is on a phone call with a Secretary of State, Brad Raffensperger in this case here in Georgia,
great question,
and is trying to, or if it appears he's trying to get votes in his favor to be awarded a victory, is that an official or unofficial act?
I suspect that'll be an unofficial act. So there's two really good examples that are related to the Georgia prosecution here in Fulton County that illustrate the difference between something which would be, kind of an official act, which may or may not fall in the category of immunity, and versus a non-official act. The call that Brad Raffensperger received from President Trump demanding 11,000 votes and change, that seems to me to be a pretty clear unofficial act because it is the president acting in his non-presidential capacity as a candidate, seeking a particular outcome for his personal benefit. A different allegation that's contained in the Fulton County indictment relates to a former Department of Justice official, Jeff Clark, where Jeff Clark was drafting a letter to the Georgia General Assembly urging them to overturn the election. So there was probably some internal conversations happening there between Jeff Clark and Donald Trump, which are off limits, both in terms of prosecution and evidence. So there will be some things that will be off limits to Fani Willis here in Fulton County.
Same professor, different podcast. Yesterday, late in the show for Politically Georgia, Anthony Michael Christ, across the hall, no, I'm sure it was on Zoom, was discussing what Donald Trump can be protected from being prosecuted for. And, a lot of us kind of made the joke about SEAL Team 6, but...
there's a lot of built-in protections for the presidency, and... I think there's a big question now. I mean, we all kind of laughed at it earlier about whether or not a president could order the execution by the military of a political opponent. The Supreme Court's answer is yes.
That was, Anthony, that was the first thing that came to mind when you said that the president is immune from official actions. His attorneys, in their oral arguments before the court, raised that very question. They said, if the president orders the military to execute an opponent, we believe that he is immunity in his official capacity to do that. There's something shocking about the way in which the Supreme Court, not without regard to just that one incident, seems to believe that that a president has such broad immunity in office.
And by the way, it's Bill Nigut, Politically Georgia podcast host. Again, do you think the Supreme Court didn't notice that argument was being made? Of course they did, because that's their job. I mean, unless they're too busy being flown away for a lavish international trip, or maybe they had to take their $250,000 RV into the repair shop and they just only got to skim over the arguments. But of course they noticed that. That has to be something that they noticed.
Yeah. I mean, I'm, again, still chewing through this, but it does seem, I'm almost shocked. I mean, I did not expect this broad. I mean, it's certainly a more narrow version of immunity than what Trump wanted, right? Trump wanted absolute immunity no matter what for any kind of acts he did while he was a sitting president.
Because he's had absolute immunity for just about everything he's ever done his entire damn life. He's a spoiled brat that just never got the ass whooping he deserved to be brought right the way the rest of us had been.
So it's certainly not that. But it is, I think, let me put it this way. I think usually when justices dissent, and this is a 6-3 opinion with the liberals dissenting, usually they say, I respectfully dissent. Justice Sotomayor said, I fear for our democracy, I dissent. Yep. Now that is justice speak for, I can't believe you're doing this. Yep. It's, I'm a little lost for words on this one.
Pia, the ruling was 6-3 along partisan lines, and that in and of itself, I think, is going to cause some discomfort among many people out there.
Yeah, and well, yes, the discomfort with, again, the rightward turn of the Supreme Court, which takes us back to what we've been talking about, which is why Democrats are so in a tizzy about what to do about the presidential race.
She brings up a valid point, but we also have to point out, the American people have said by popular vote that they would actually like to see the court take a leftward turn, except for the goofiness of the Electoral College that, again, needs to be dealt with. Let me get to the AJC piece that talked about the impact on the Georgia election interference case. Fulton County Superior Court Judge Scott McAfee will need to decide which of the 10 remaining felony counts against Trump can pass muster under the high court's decision. The question was Trump's conduct, such as his January 2021 phone call with Georgia Secretary of State Brad Raffensperger, official and thus must be dropped from the indictment? Or is it unofficial and fair game for prosecutors? We heard Anthony Michael Christ speak to that with Rose Scott on WABE. He did say on the same Politically Georgia podcast, though, that the ruling, quote, has, quote, some very deep implications for what Fulton County District Attorney Fani Willis is trying to do here. A spokeswoman for the Fulton County DA's office declined to comment to the Atlanta Journal-Constitution about this story. McAfee is unlikely to address the matter anytime soon. I mean, why now? I mean, we're all it's up to the American people at this point in time. Got to put your earrings in, your heels on, grab your purse. You got to go bail the country out, ladies. Fellas, if you wear that too, that's fine. You can. Anyway, McAfee unlikely to address the matter anytime soon because the Georgia Court of Appeals recently issued a stay pausing most pretrial work in the case as it considers whether to remove Willis from the prosecution due to her alleged conflict of interest with Nathan Wade. No conflict of interest exists because they were on the same damn side, but that's just a technicality. Let's continue on with this charade. Legal experts reached Monday differed in their opinions of what the decision could mean for the Fulton case. Some believe the high court's conclusion that immune action stretched to the, quote, outer perimeter of a president's official responsibilities meant that Willis could have a hard time keeping much of a racketeering case against Trump intact. Atlanta defense attorney Andrew Fleischman, I think this does hurt the Georgia case quite a lot. He's closely tracking this. There's not much clear guidance at all. I think Georgia courts will likely have to apply this novel analysis, and that creates a lot of opportunity for delay. Fleischman noted that the decision creates new evidentiary headaches for prosecutors since it bars them from using official acts taken by the commander-in-chief, including speeches as president or discussions with Justice Department officials. Such acts are cited as so-called overt acts in the racketeering indictment. You've got the potential to really hamstring the case, he said. Everything today in the show notes at ronshowatl.com, replaying 5 to 6 p.m. on the American One Radio app and on demand at progressivevoices.com. Y'all have a good day.